another question. It says, do you prefer lawyers, paralegals, and students using the small claims court form to keep the claim relatively short? Or do you encourage people to use a Schedule A?
Well, I think that depends on the case. I mean, if it's a straightforward contract case with one document and their allegation is that there's a breach of contract, then the body of the claim may only be a few lines long. But if it's a complicated matter, let's say it is a home renovation gone bad, and there's been a number of issues that have arisen, take as much time as you need, or as much space as you need, rather, to set out the parameters of the claim, because ultimately that's what a settlement conference judge or a trial judge is going to be looking at. The more detailed you can be when it calls for detail in order to establish the parameters of your claim, then utilize a Schedule A. I don't think that the preference of the judges, it really just comes down to what nature of the case. That would be my thoughts on that.
If I could just add to that, you should look at your pleadings, be it a defense or a claim, as your first chance to advocate your case. So pleadings are advocacy. And I think the Schedule A document, instead of doing it on the pre-printed form, is a much better way to advocate. I think it's more persuasive. And that is the first thing a judge is going to read, either at a settlement conference or a trial, about your case. And you want to draft it in a very persuasive way. So at least on the preliminary stage, a judge is going to understand the strength of your case and its background. In small claims, you're not bound by the rules of pleading that you are in superior court. And you should, in other words, you have to plead facts, not evidence, in superior court. That rule doesn't apply in small claims court. So as Paul indicated, do it chronologically and make it concise